Hello, welcome. Disability Law Show back again for another week. So glad to have you with us. John Scholes here. Beside me, James Fireman, partner, Samfiru, Tumarkin, LLP, the most positively reviewed disability law firm in the land. I'll tell you right away how you reach out to James anytime. We're not doing the show, this or the radio shows, 1-855-821-5900. Help at disabilityrights.ca also works. James, lots to get on the show today. In fact, we're going to cover common misconceptions about beginning an LTD legal claim a little later on the show. That we'll get to some emails from our listeners and our viewers as well. But you always start with an interesting situation you've been working on, pal. How are you?
Well, I'm doing well, John. I'm doing well. And I'd like to start this show off talking about a recent case where the issue of surveillance came up. And you know, this is something that really only comes up from time to time, even though it is something that a lot of clients have a great deal of fear about. So I thought it would be a good opportunity to discuss this, to dispel some of the myths about surveillance. First of all, it is rare. Think about surveillance as what it actually is. It's something where the insurance company has to go out and hire someone else to conduct investigation of you. That means the insurance company is going to be spending their money, which they don't like to do. So it isn't something that they do all the time. In fact, it's something that they do quite rarely. I see it maybe 10, 15% of the time, if that. The other big misconception, though, is that when they do surveillance on you, all of a sudden it's going to sink your claim. Quite the opposite. If that, in fact, were true, you would see insurance companies doing it much more frequently. Yeah. The reality is the vast majority of surveillance that's conducted is completely useless. And many times it actually winds up helping your case. So let me talk to you about, how that can happen. So, you do occasionally hear stories about someone who says they can't get out of bed, and then there's surveillance conducted of them and they're tiling a roof or something like that. Obviously, if that's a situation, if you're telling people that you can't get out of bed and you're tiling a roof, yes, the surveillance is going to sink your claim, as it should. You shouldn't be getting disability benefits if you're lying about what you're capable of doing. And I have no issue with that with an insurance company conducting surveillance if you are in fact trying to cheat the system. That's perfectly fair. But it's rarely what happens. More often than not, it comes up with nothing. So usually when I look at an insurance file, if there is any surveillance, I'm going to get the entire surveillance report. And that's going to give me a lot of information about what actually happened. If there is surveillance and if the insurance company reveals that to you as the insured person, they're typically only going to cherry pick one or two details and only the details that help them. But when I see the insurance file and I review the entire surveillance report, I'm going to see exactly what happened. It's going to tell me exactly how much surveillance was conducted. How many hours was the investigator hired in order to follow you around and see what you were doing? How many observations was the investigator able to make during that time? And that can be really useful information to help you. And let me show you why. So I told you this was triggered by a recent case that I had. This was a gentleman lived in Ontario, and he had a neighbor who sent an anonymous tip about activities that he was doing, exercises in the backyard and doing some yard work and that sort of thing. Mm-hmm. Now, in some cases, that might hurt your claim, but these were all activities that he had told his insurer he was doing and told his doctors he was doing, and that were recommended for him. It wasn't anything out of the ordinary. So it shouldn't have been anything that triggered the insurance company to follow up in any particular way, and yet they did. This triggered surveillance for the insurance company. Very shortly after, they hired an investigator who followed my client around for a total of 33 hours over several days. And when I got that insurance file and I looked through the surveillance report, I saw exactly what happened, 33 hours, and there wasn't a single observation, not one observation made of my client during that time. They didn't see him leave the house. They didn't see him around the house doing anything. This, in fact, became a really strong point in favor of my client. I know this because we went to mediation quite recently and we resolved it for a good amount. But at mediation, the insurance company didn't make any reference to surveillance at all. That wasn't part of their argument, even though they had cut my client off very shortly after they conducted the surveillance. But the surveillance was a big factor. In fact, it was a factor that I argued very heavily. I leaned on that as strong evidence that the insurance company knew that my client wasn't doing anything. And they knew this because they went out of their way, they spent their own money to see what my client was doing. And they had a report that showed he wasn't doing anything, and they ignored it. That is compelling evidence. And I told the insurance company that if the case were ever to proceed to trial, I was going to call the investigator that they had hired as my first witness to make sure that that evidence would be in front of a judge. And they knew that that was a problem for them. And that compelled them to put a lot more money on the table than they otherwise would have liked to have done. The point of all of this is that, one, surveillance is pretty rare. And two, when it does happen, more likely than not, it's going to help your case, not hurt you, especially if you have a legitimate claim.
Does the insured person who's being watched, do they ever have any clue that they're being, or they're under surveillance?
Well, it can happen. I mean, it depends really how good the investigator is at maintaining anonymity. They're supposed to try and make sure that they're not discovered by the person they're investigating. Otherwise, obviously, the person isn't going to do anything that is going to jeopardize their claim. But now and then it happens. You won't know if you're being followed. You won't know that it is an investigator. They're not going to be wearing a sign that says, "I work for your insurance company." And so, what I do like to tell people is, if you notice that you're being followed while you're on a claim, or not, frankly, for that matter, but if you do have an ongoing disability claim and you notice that you're being followed, don't assume that it's a private investigator hired by your insurer. It might be, but you don't really know, and you don't want to mess around with that. You have to make sure that you protect your safety at all costs and the safety of your family. So if there's somebody who shouldn't be there that's following you around, call the police, file a report. Make sure that there's a record of that, because if it is someone else, you want to make sure that you're protected.
It's interesting. You mentioned this client was watched for about 33 hours. I don't know what surveillance costs. Maybe you do, being closer to the business, but I would think that if they're going to spend that kind of money, and if it is so rare with the low percentage of surveillance being used by insurance companies, they would want to get something out of it. I'm surprised they didn't bring it up in your mediation. Get their money's worth.
There's nothing to bring up. There was no observation. But you're right. I mean, when they do spend money on surveillance, they do it with the expectation that that's going to help them do what they want to do, which is to cut off benefits. And so they will distort it or cherry pick or use it out of context as much as possible in order to get to that point. And so you see that happen all the time. Surveillance that really shows nothing, that the insurance company will use as a justification to cut off benefits, because they have to justify having spent that money on the surveillance.
I guess the moral of the story that you always say is, if you've been told, or if you've been given certain instructions what to do and what not to do by your medical team, if you're complying with that, then you really have nothing to worry about. Just live your life.
That's it. That's exactly right. If you are doing the things that you're supposed to be doing, if you are using common sense, if you are following the instructions from your treating doctors and therapists, then you don't have anything to worry about, because anything that the surveillance investigator sees you doing is going to be within the medical file as something that you are well entitled to be doing, and in fact, in many cases, should be doing.
Again, to reach out to James anytime when the show's not on, if this piques your interest, or if you have questions, have a chat, 1-855-821-5900, help@disabilityrights.ca. I wanted to mention the website as well, James, pocketemploymentlawyer.ca. I know it's got employment baked into the title, which is the other show we do, of course, but why mention on this show? Because there is a section on disability law if you scroll down the Pocket Employment Lawyer website there just a bit. And why is that there? Because there's a lot of crossover between the two. I know you've talked about it. Savant's talked about it on this show as well. And it really is interesting to open up that piece and just go through some of the questions. Are you on disability? Yes. Have you been cut off? Yes. Another drop down. Was it before or after 2 years? Yes. It puts you through a whole bunch of quick questions, easy to answer, and then there's contact at the end of it. So it's really handy if you are on disability and you have any questions about that. It is yet another resource for you to use at pocketemploymentlawyer.ca. First email of the day, James. I know you want to get into this. help@disabilityrights.ca. John says, I've been receiving long-term disability payments for over 3 years now. Due to macular degeneration, the insurance company just contacted me to offer a lump sum settlement if I give up my ongoing benefits. Is this something I should consider?
So it's an interesting question. So
Yeah.
should you consider it? Sure, but you want to be very, very skeptical. Remember, the insurance company isn't going to propose a lump sum settlement unless they think it's going to be in their own best interest, not in your best interest, but in their own. So that is always what's going to be driving that sort of an offer. But that doesn't mean in all cases that you should just ignore it. You should at least see what's on the table before you check their offer. So first, you want to figure out what your claim is worth. How much should you reasonably expect as a lump sum payment so that you can compare that to what's being offered. And to do that, you first need to figure out what is the insurance company's total exposure on your claim. When I say exposure, what I mean is how much money would your claim be worth if you continued to get your monthly benefits all the way through to age 65? Doesn't mean that is what your claim is worth. That's just the maximum exposure that your claim is worth. So how do we figure that out? Well, I know you were told there wouldn't be any math. There's going to be just a little bit. So first, you got to figure out what is your monthly benefit. You know what this is. It's the amount your insurance company has been paying you every single month, however long you've been entitled to get your LTD benefits. That's the easy part. Now, this is where you have to do a little bit of math. Take out your calculator. Take that monthly amount, multiply it by 12. That is the yearly benefit amount. This is still pretty easy. Now, all you have to do is figure out how much time do you have between now and age 65. You can round it. This is just going to be a round number. That's fine.
Mm-hmm.
So, if you have 10 years, 15 years, whatever it is, multiply that number of years by that yearly benefit, and that's your exposure. That is the maximum amount your claim would be worth if the insurance company paid you out every month until you're 65. Now, are they going to offer you the maximum exposure? No chance. Never going to happen. That's not even a possibility. That is not something that they're going to offer you. But it still might make sense in certain circumstances to consider taking something less than that. The question is just how much less, and why would you make that consideration? Well, there's several reasons. One, for some people, their disability isn't necessarily something that will keep them disabled from working until they're 65. So you have to consider the likelihood that you will return to work in the future. You also have to consider the likelihood that even if you are disabled, that your insurance company might cut you off anyway. If you do get a lump sum settlement, you don't have to worry about that anymore. You don't have to worry about what your insurance company is doing. There's also a value to getting the money now. There's time value to money. Over time, your monthly benefit, if it isn't adjusted, is worth a little bit less each year. And so getting it all now is worth a little bit more. And you also don't have to deal with the insurance company anymore. You don't have to get calls from the adjuster. You don't have to go to their assessments, which is nice. I don't know what the value of that is to any individual person. It's something that you have to decide for yourself, of course, but there is some value in that. The other value, and this can be significant if it applies, is the tax issue. So if you have a taxable policy, every month when you're paid your benefits, the tax is deducted and remitted directly to the CRA. If you accept a lump sum payment, though, all the amounts for the future benefits are not taxed. That is not taxable. And that is a huge advantage to taking a lump sum payout. And it's something you absolutely should be considering when you're weighing the value of your potential lump sum payout versus how much you might get in the future. So there are reasons why you would consider taking something less, but the biggest variable is really how long are you going to continue to be unable to work? And if the answer is you're never going to be able to go back to work, well, then you want to make sure that that offer is pretty darn close to the exposure. It's not going to get there all the way, but it should at least be approaching that if you're certain you're never going to go back to work. So getting back to John's email, John emailed us because he's got macular degeneration, which, as I understand it, is an eye condition that gets worse over time. And there's a really important piece of information that John provided us in his email. He's been getting benefits for 3 years, which means we know that he's been getting benefits already 1 year into the any occupation phase. His insurance company has accepted that his macular degeneration prevents him from doing any occupation that he is qualified for by training, education, and experience. And because his condition is degenerative, it's right there in the name, there's very little chance that that's ever going to change. And so his insurer is going to be on the hook in all likelihood to paying benefits until age 65. So Should he consider a lump sum payout? Sure, but it better be pretty close to the full amount. In any case, if your insurer is approaching you about a lump sum payout, you can give us a call. We're happy to listen. We're happy to provide you with our advice. And if it's something that we think we can help with, we're happy to do a full review and provide you with the formal opinion.
Before we break, let me ask you this. In your experience, yeah, I know obviously they're not going to offer you, all of it, because that would make no sense. In your experience, what do they usually come to the table first with? 50 cents on the dollar, maybe a little over half?
You'd be lucky. You'd be lucky if that. So
really?
Oftentimes,
Wow.
Where we see it happening is in people who are typically a little bit younger, that have 20, 25, 30 years of benefits ahead of them, where they can cook up a number that looks pretty large on paper.
Yeah.
I mean, let's say you're getting $4,000 a month. That's $48,000 per year. After 2 years, you're pretty close to $100,000. So if they were to put, say, $300,000 on the table, that's really the equivalent of a little bit more than 6 years worth of benefits, which looks like a lot of money. But if you're not going to work for the next 30 years and you're supposed to be getting benefits for that entire time, it's really a fraction of what the case is actually worth. That's what we see far more often, where they're able to put up a number that looks big on paper, but is really just a fraction of the full value of the file.
And with that, we will take our first break. Coming up here, common misconceptions of filing an LTD claim, so stick around for that. The number, as James mentioned, to reach out anytime, 1-855-821-5900, help@disabilityrights.ca. There's more coming up. Stick around.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, welcome back to Disability Law Show. Thank you so much for hanging in there. 1-855-821-5900. Anytime to reach out to James and his team. Help@disabilityrights.ca. James, let's get into these. Fire and match your common misconceptions of beginning an LTD legal claim. Number one, the process for filing and pursuing your disability benefits is long and arduous.
Yeah, it's actually pretty straightforward. So most disability claims are going to start with 3 forms. There is the plan member statement. That's just a form that you fill out on your own. It's got your basic details, your contact information, what your disability is, and some information about your symptoms and how that impacts your ability to work. It'll also have information about your treatment providers. Then there is the plan sponsor statement. So if you have a group disability policy, your employer is typically going to be the plan sponsor. And they will fill out that statement, and it's basically just going to be an overview of your occupation. So it'll give details about how long you've been employed for, what your salary is, what your job title is, and it will often give an overview of the duties and responsibilities, and sometimes it'll break it down into what the physical requirements are of your job, how much sitting, standing, lifting, walking, that sort of thing. So that's the second form. And the third, which is by far the most critical, is the attending physician form. And so that's going to be filled out usually by a doctor. More often than not, is filled out by your family physician, because they're often the one who's in the best position to be able to give a broad overview of all the treatment you're getting, especially if you have several specialists involved in your care. Sometimes, though, if your disability is predominantly a mental health disability, you'll see psychiatrists or clinical psychologists fill out the attending physician form and submit that. Sometimes you'll see both. You'll see the family doctor and a mental health form filled out. The point is this, though, there's really those 3 documents to initiate the claim. And of those 3, you really only are filling out 1, and you're just making sure that your employer and physician fill out the others in a timely way. Beyond that, in terms of the application phase, really all you're doing is you're going to be making sure that your clinical notes and records from your treating doctors are sent to the insurers. And this can often be done by the insurer directly. If you're willing to give your consent to the insurance company to get them directly, that makes it a little bit easier. Some people prefer not to do that and prefer to, make sure that they're aware of everything that's being sent, which is perfectly valid. It just means a little bit more legwork on your part. And if you do that, you have to really make sure that you're on your doctors and that they are sending the information in a timely way.
All right, number 2 of the misconceptions about filing an LTD claim is this, James, that the person filing the claimant is really heavily involved. It's going to take a lot of time and a lot of effort to get through the process.
So once you've applied, the biggest issue, the biggest thing that you have to do as an applicant is complying with treatment. So taking your medications, going to therapy, regularly updating your doctors. These are things that you'd be doing anyway. So this really isn't specific to applying for long-term disability. If you are doing, what common sense dictates, which is following what your doctor's advice is, then this isn't an additional thing that comes with the disability claim. In terms of dealing with the insurer, there's typically an initial phone call shortly after they receive your application package with those 3 documents. That phone call is usually about an hour or so. It's fairly in-depth. The claims handler assigned to your case is going to spend some time asking you all sorts of questions about your disability, about your occupation, about your symptoms, about the things that you're limited in doing with your occupation. It is a very broad conversation, but keep in mind your insurance company is doing this because they want to see if there's a valid basis for denying your claim, if there's something that you're going to give to them. It's important to be straightforward here. You don't want to start lying with your insurer and trying to shade evidence. Everything's going to be in your medical file anyway. So it's important that you are forthright with your insurance company. Just tell them the way that it is. If you have a valid claim, then they ought to prove it. They might not, but they ought to. After the initial claims process, after the initial adjudication, usually it really settles down from that point if you're approved. If you're approved, typically there isn't a lot of interaction after approval until you get to the change of definition, which is 2 years down the road, sometimes a little bit before that. But usually the process after the initial assessment is pretty limited.
Yeah, it's interesting you mentioned communication because that's the third misconception about this, and the fact that the insurers are really unresponsive once they receive that claim. Not true.
It happens on occasion. Every now and then I'll have someone contact me and say they applied and it's been 7 or 8 months and what's the insurer doing? And there can be various reasons why that happens in those rare cases. Sometimes there's legitimately a lack of information, or there's a doctor who hasn't provided their file in a timely way. Sometimes it's just the insurance company being lazy about it, but it isn't a problem that I see all that much. Typically speaking, once you apply, we see decisions in 1 to 3 months in most cases, and that might seem longer than it ought to be, and perhaps it is, but it's not completely unreasonable either, and it isn't something that I see as a predominant theme. It's something that comes up now and then.
We'll get to our last one is this, James. Again, common misconceptions when filing LTD claims, and that is the clients don't have many options or power when pursuing those rights.
Well, no, that's not at all true. So first and foremost, while you're in the claims process, it's really important that you assert whatever power you have. And the way you do that is you make sure that your side of the story, your version of events, is going to be captured. So here's what I mean. When you apply, the insurance company is going to open a claims file for you. That claims file is meant to have a collection of all the relevant information in your case. So we'll have summaries of all of those application documents. We'll have summaries of all of the medical information received throughout the claims process. But it's also going to have a summary of every conversation and every email that you have with your insurance company. They will summarize all of that and put that in the claims file. You want to make sure that that is recorded accurately. And if you don't send an email every time your insurance company calls you, then you're leaving it up to your claims handler to summarize what that call was about and what was said. And if they're left to their own devices, they're going to shade it in a way that is going to help them justify terminating your claim down the road. That's just what happens. Yeah. So you need to get into the practice as soon as you file your claim, as soon as you submit your application. Every time you have a phone call with your insurance adjuster, you want to make sure that you are taking comprehensive notes about what was said, both by the claims handler and by you. And after that call is over, you want to put that into an email and send that so that is captured in your claims file. So there can be no dispute about what you said and about what they said, or at least if there is, that it's recorded on that day so there isn't an imbalance there. If you don't say anything about it at the time it happens, and then 6-8 months down the road, we bring a claim and I get the file, and there's no record of your version of events on file because you didn't send an email, there's not really going to be a good way to dispute what's in the file. So that's why you really need to make sure that your version is written down and sent to the claims handler as soon as that call is finished.
All good stuff. We'll take a short break. We've got a few more minutes to get through an email or two, and we'll do that after the break. 1-855-821-5900. Disability Law Show continues.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, welcome back. Just a couple minutes to go on the Disability Law Show. James, I want to get to a question from mydisabilityquestions.com. That website, by the way, is free and anonymous for anybody to use. From Janelle, says, I just found out that I'm pregnant. I've been off on long-term disability for the last few months and likely won't be returning to work anytime soon. Can the insurance company stop my LTD payments and force me to apply for EI maternity benefits when the baby is born?
Really good question, Janelle. First of all, congratulations. That's wonderful news. To answer your question, I'll answer it the way I answer most questions like this, which is it depends. You really have to look at your policy. I have seen policies that would do exactly what you're worried about, with policies where if you are pregnant as soon as you have your baby and you're entitled to EI maternity, that the insurance company would not be required to pay benefits during that time. That is possible. I've also seen policies that are completely silent on that issue. And so you want to take a look at the policy, and if there isn't anything that is explicitly giving your insurance company the right to stop benefits after your baby is born, then they don't have it and they can't take it. So make sure you look at your policy. If your insurance adjuster is saying they have that right, ask them exactly what part of the policy they're relying on and have them send that to you so you can make sure. And if you want, you can give us a call, and we're happy to review it.
And that'll do it for another show. Appreciate you tuning in and helping out with the show as well if you wrote in. 1-855-821-5900. Help at disabilityrights.ca and mydisabilityquestions.com as well. We'll catch you next time.